Hello, I'm Darren Dake with the Death Investigation Training Academy, and today we're going to talk about testifying in court and preparing for that testimony. Now, I'm going to slide out of the way here, and I'm going to bring up some PowerPoint slides, and we're going to talk about the court process and preparation. And I'll probably bop in and out here a little bit during the presentation to clarify a few things. So let's go ahead and get started on the course now. So one of the first things to understand is there are two types of witnesses in any court action. There's a factual witness and there's an expert witness. Now, a fact witness is someone that has personal knowledge of the events pertaining to a case and can only testify to the things that he or she personally has observed, seen, or done. Now, an expert witness is someone that offers an opinion, and that may assist the judge or the jury in understanding maybe a specialized technique, maybe something to do with the science or forensics, but otherwise would be beyond the normal person's expertise. They are an expert witness. So I have to ask, could someone be a fact witness and an expert witness at the same time? The answer is yes. You may be asked about what you did and what the defendant did. You'd be a fact witness. And then you could also be asked to state your opinion, and then there you'd be an expert witness. So this comes up sometimes when you're dealing with an inquest. Of course, during an inquest, the rules of court are a little bit different. But also in a criminal case, you can be the fact witness and the expert witness, depending on the kind of the case itself, and obviously in civil cases as well. Example would be that you saw a suspect walk into a store with a gun and you thought he was going to commit a crime. Well, the fact is you saw somebody walk in the store with a gun. The expert witness portion is you thought he was going to commit a crime based upon your knowledge, your years of experience, and of course the common sense would tell you that very likely could happen. Now let's talk about preparing for your testimony. You need to have a well-organized, standardized, complete, and readable report. A lot of times I see people going to court and they've got this pile of stuff that is just in no way in any type of order. And so it's very hard to prepare for testifying when you don't have things in a good order. Supplement standard forms and checklists with your own words to help explain potentially confusing situations. There's a lot of checklists out there. There are a lot of scene checklists and report checklists. Those are fine. But if they get confusing to you, then replace that with something you can understand. Your own words, your own way of saying things, and that way it'll help you when you do get ready to prepare to be able to testify based upon your knowledge and your own understanding. And then, of course, it's okay to draw pictures to help describe things and to jog your memories during court. These are papers that you're going to be able to look at. Now, they can be put in as records, so be careful what you do right in there. But obviously, pictures and diagrams are a good part of your summary. Now, you should review the case several times before you go to trial. So you've been called, you got a subpoena, you know when your court case is. You should review the case several times before you get there. You should also meet with the prosecutor and review your testimony. What is the prosecuting attorney going to ask you? What does he or she feel is the most likely defense that you're going to have to overcome? And how best do they want you to prepare? And you need to mentally rehearse the case, going over the facts out loud. Talk about the facts. If he asks you questions, prepare your answers. You can do this alone, in your car, in your house, whatever. Just do it somewhere where you can actually prepare and get used to answering these questions out loud. It'll help you when you get to the actual witness stand not to be so fearful. And if need be, visit a courtroom and observe other trials in progress. If you've never testified in court and this is your first time, then yes, go somewhere where they're having court and watch as court proceeds so that it's not something new for you and some of the anxiety of newness is over with. Now, ask yourself long before you ever get to court, is your report complete and accurate? A report should be written in chronological order of your investigation or your involvement from the time you received the call, got the information, seen the situation, was contacted by someone else. That's where it should start. and it should be in chronological order until you have completely finished your portion of the investigation. That way, anybody coming along later can understand it, and you can understand it as well. Easy to understand reports need to not have short codes or police jargon. We don't, sometimes car accidents, if there is a deceased in a car accident, we'll refer to that as a 1050 J4. 1050 being the accident, J4 being someone is dead. You don't want to put that in your report. You want to just simply put what it was. Traffic accident, someone was dead, someone died, however the situation is. Don't use short codes. Don't use things that are for your department, your agency, because someone else might pick that up and not be able to understand it. And be sure that any words or phrases that you use in your report, you can explain later. The biggest embarrassment you're going to have is when you have to look up one of these $5 words when you're explaining an injury or an illness, and then when you get to court, you don't remember what that word meant. Or you can't explain it correctly. Because I promise you, the defense attorney is going to have 5 more words for you to explain and make you look like a real idiot. Now, if you know what the word means and you can explain it, then by all means, use it. If you're going to use the word myocardial infarction, make sure you can explain myocardial infarction. If you're going to use the word laceration, make sure you know the difference between a laceration and an incised wound, because the defense attorney is certainly going to look that up, and he's going to be asking you. And if you can't describe the difference, he's going to make you look like an idiot. So you can use things like defects, or you can marks on the body, appears to be, but be sure whatever phrases you use, you can explain. Now, your opinion can never be reflected in your final report. Someone may ask you your opinion, the prosecutor or even the defense attorney, but in your final summary report, it can only be the facts as you have done them and know them. Now, in your investigative notes, certainly you can have some opinions in there, but your final summary must have facts only. Now, when you get to court, make sure you have a complete report with you, and make sure you have reviewed all of these reports, meaning the autopsy report, the toxicology report, and anything else that may be related to that. Make sure you look at the evidence logs. You know what evidence has been put in. Do you have the evidence? Did the prosecutor ask you to bring the evidence with you? If so, you have to go sign for it and bring it to court. Keep it with you until you return it to the evidence. But make sure you have reviewed all of that long before you get to court, and then again, either the day of or the day before. Now, let's talk a little bit about PreTrial Stress. The 1977 bestseller Book of Lists? Now, in it talked about the 14 worst human fears. And the number 1 is speaking in front of people. And number 2 is dying, by the way, which means we would rather die than get in front of people to talk. When it comes to court, not only is there the fear of talking in front of people, we also have the fear of the weight of the court, actually. We're there, it's court. You don't want to be wrong, you don't want to lie, you don't want to look like an idiot. So all of these are fears, and so there's a lot of stress built up on it, even more so than just if you were speaking to your peers about something. But you can overcome this fear. So I want to talk a little bit about how to overcome some of this fear and some of this stress before we actually get into some real courtroom testimony. Now, this fear can be overcome by mastering 2 skills: breathing and relaxation. Breathing and relaxation. If you can master these 2 skills, you can overcome your fear in court. So breathing. It's something we all do, obviously, and we don't even think about it. And so for so many people, military and posture training has resulted in poor breathing habits. Military trains us to breathe one way. You breathe when you shoot. Certain postures, the way you sit helps you breathe. But a problem is that is poor breathing habits, So ask yourself, do you think you're breathing correctly? Probably not. Let's look at that. The diaphragm is a muscle located just under the lungs. Now, most of us know that. And when the diaphragm flattens, it creates a greater space in which the lungs can be filled. And when the diaphragm returns, the air is literally pushed out of the lungs. So to see if you're breathing properly, stand up, close your eyes, hold your fingers on one hand just under your rib cage, 2 or 3 inches above your belly button. Inhale. Now you should feel here that the muscles will move up and down, and you can feel that through your fingers. Now relaxation. Fear, tension, and or stress can cause your muscles to tighten. And this can be fixed by completing a simple exercise. And just before you go into court, do this exercise. Just excuse yourself to the bathroom. I don't mean when they call you to testify. I mean just make sure before you go to court, before you go into the room, excuse yourself to the bathroom and do this exercise. Stand up, tense your toes, and just actually drill your toes into the floor. Make them tense. Tighten your calf muscles. Move the tension up to the thighs and into the hips. Tense your forearms. Moving the tightness up into your arms and in your chest and down into your stomach. Tighten every muscle in your body. Go into your head, your neck. Your body should be so tight from tension that it's shaking. Now raise your arms over your head and stretch as far as you can. Now, totally relax. Drop your arms, loosen all those muscles, and you can feel a surge of well-being taking over. It is a fantastic way to relax. If you're in a stressful situation, you can do this as well, not just court, anytime, and it will help you to relax. Now you're relaxed, your fear is gone, and you're ready to take the stand.